It's 12 weeks, eh?
Man, it's gone quickly. Very quickly.
Hello, everyone. Are we good to go, or should we wait for the others? Can you hear me? Hello, can you hear me?
Yeah, we can hear you.
Okay.
Here we go, Manjo.
Do we wait for the others, or should we begin? Chat. Good to go. Okay. Hold on. Just grabbing a piece of paper here. Okay, so before we proceed, well, tonight's session is going to be on constitutional rights and freedoms. But before we start talking about the subject, I was hoping to cover a little bit of the legal memorandum, especially concerning the notion of matter, which quite a few found difficult to answer. Actually, there was only one person who answered it correctly. I can't remember who it was. It was a lady. Everybody else got it wrong. And I think the confusion, well, there seems to be a lot of confusion about what matter is. And so I'm hoping to devote a few minutes on the subject. I don't think there's an issue about us going beyond 8 o'clock. So it shouldn't be a problem. And more importantly, I wanted to discuss the notion of matter because it will be covered in the final written online assessment. Okay. Are you happy to do that?
Yep.
Okay, good. So, where do I begin? Hold on. I'm just going to stop sharing the screen in the meantime so you could just see me. Ooh, what's that? You can't handle the truth. Okay. Shouldn't it be my photo? We should be there. Is my photo appearing there somehow? Or my image?
Yes.
Okay, it is. Okay, good. So let's talk about the issue of matter. The concept of matter is very important because at the very least, it's the basis for the courts to have jurisdiction. So anything that pertains to matter, especially as far as the High Court is concerned, it belongs to the judiciary to decide or adjudicate. I'd have to ask everybody else to turn off his or her microphone. I think I'm getting some feedback there somewhere. I don't know how to mute everyone. So let me repeat. The notion of matter is important because if you look at the Constitution, it states there that both under Section 75 and Section 77, that the original jurisdiction of the High Court pertains to all matters, okay? And so there has been a definition. What was that? What was that? Kind of heard somebody. Was that a question? Oh, for those who have no intention of speaking, I would have to ask you to turn off your mic because I wouldn't know if you wanted to talk or whatever, or, so just turn off your mic.
You can mute it.
I could hear you.
You can mute everyone.
I'm hearing a lot of people. How do I turn off?
Manjo, you can mute everyone's mic from where you are because you're the host.
Yeah, but I'd like you to mute your mic if you could. Can you do that? Can you mute your mics? Okay, that seems to be better. Okay, good. So as I said, the concept of matter, the legal concept of matter is crucial because that is the basis on which the High Court and courts or Chapter 3 courts are able to exercise jurisdiction. And that's crucial as well because matters are exclusively for the courts, and non-matters, therefore, are not for the courts. And if it is not for the courts, it means that typically non-matters would go to the executive, in the form of non-Chapter 3 courts, or what we call administrative tribunals. And remember, we're talking here at the level of the Commonwealth government, or we're talking at the level of the federal government, not the states. Okay? Now, as I said, that's crucial because if you follow the Boilermakers case, Amalgamated Society of Engineers, no, if we go by the Boilermakers case, the High Court had ruled that Chapter 3 courts can only be vested with judicial powers, and it would not permit the vesting of non-judicial power on Chapter 3 courts. And at the same time, in the Boilermakers case, the High Court ruled that that non-Chapter 3 courts are permitted to exercise judicial power. So that's crucial there. And we have the classic definition of what matter means in the case of Huddard Parker versus Moorhead, where the High Court defined matter as one involving an actual controversy between the state and its subjects, or between subjects, involving rights, liabilities, and freedoms. So that is the classic definition of a matter, and especially where it involves the power to make a binding and a final decision. No. Martin, I just said that non-Chapter 3 courts cannot exercise judicial power. So judicial power can only be for Chapter 3 courts. So under the Boilermakers case, there were two propositions there. One is that the High Court would not allow the vesting of non-judicial power on Chapter 3 courts. So the vesting of non-judicial power on Chapter 3 courts is not permitted. And at the same time, it said it would not tolerate the vesting of judicial power on non-Chapter 3 courts. Okay, the internet is lagging. Hold on.
Sorry, Manjo, can you repeat that? I didn't catch most of that.
Okay, I'm just trying to check if my problem is the Wi-Fi. Okay, let me repeat. So under the Boilermakers case, there are two key propositions, and this is important. The first is that the High Court, under the notion of partial separation of powers, will not tolerate the vesting of judicial power on non-Chapter 3 courts. So if it is not a Chapter 3, oh, there's a problem with the video. Okay, let me repeat. So if it is a non-Chapter 3 court under the Boilermakers case, it cannot be vested with judicial power. At the same time, the High Court ruled that it will not allow Chapter 3 courts to be vested with non-judicial power. So those are the two key propositions. Now, in relation to how we define judicial power, we have the classic, that's my daughter, we have the classic definition of judicial power as found in the case of Huddard Parker versus Moorhead, where the court defined judicial power as that involving an actual controversy between the state and its citizens or its subjects, or between subjects of the state, involving rights, liabilities, or freedoms, where there is a power of the part or the court or of a tribunal to make a final and binding decision. So that is the definition of judicial power. And the High Court ruled that judicial power relates to matter as defined as stated in the Constitution. And the reason why the High Court in the Boilermakers case emphasized the importance of the non-vesting of judicial power on non-Chapter 3 courts, or the vesting of non-judicial power on Chapter 3 courts, is the fact that the judiciary is more or less the final bulwark of protecting government, of protecting freedoms, because of the notion of the partial separation of powers. So because the parliament and the executive are almost one and the same, they commingle because the members of the cabinet, which comprise the executive, they also belong to the parliament. It was now left to the judiciary to provide a check and a balance on the executive and the legislature. So we begin with that clear statement of legal principle. Now, how do we give examples of matter? Because matter still, to a lot of us, would be quite abstract. And what I'm going to do is to provide some examples. So the key idea about the matter is the issue of an actual controversy between either the state and its citizens or subjects, or between the subjects of the state. So in other words, if it's between the state and the subject, it could be because somebody has filed a complaint against the government, for example, because against the Commonwealth government, because he has been deprived of his freedom because he has been arrested. Okay, so that's going to be that will be an issue between the government and the state. But the typical notion of the typical notion of an actual controversy would be between subjects. So in other words, if somebody owes me money and he doesn't pay, then I sue him. That is obviously, again, an example of an actual controversy. Okay, so that's a matter. Now, what are
Can I say something, Manjo?
Yes, go ahead.
So it doesn't become a matter till someone complains about it. Is that right?
It's more specific than that, because it's actually possible for a person to complain in the sense that, for example, you go to Centrelink and Centrelink does not give you the benefits that you want. In that case, you complain. There is a complaint because you want the decision of Centrelink, for example, to be changed. So there is a complaint. But when you think about it, in that situation, there is no, it's not between subjects, and it's not so much about you suing the government per se. Okay? So when we speak of going now to the notion of what will not constitute matters, let's take the case of an instance where there is a law which under which a tribunal, whether we consider it a court or a non-chapter 3 court, and that's the basic question of whether or not judicial power is being exercised. Let's assume a situation where that agency has the power to revoke the license of a person, maybe as a plumber. Okay, so you see that situation there. If you look at it, if that agency or tribunal can, on its own initiative, revoke the license, then there is no actual controversy. In other words, when you speak of a matter, it is something that would typically fall upon the court. Somebody brings a legal controversy before the court. It doesn't look for the controversy on its own. And it has to be an actual controversy. Okay? Or we might have a situation where the power to investigate whether or not a breach of employment law has been committed. In that case, there is no actual controversy. In fact, it is that agency which seems to be looking for the breach of an employment law. Is there a controversy? The answer is no. Because in that case, the agency is undertaking the task of investigating whether or not a breach of a statute has been committed. In that case, again, it does not involve a matter, and it does not therefore involve the exercise of judicial power. Are we clear so far?
Sorry.
Yes.
Complaint I shouldn't have used the word complaint. Maybe I should have said it's not. It becomes a matter when you take the issue to court. Is that right? It becomes a matter when you take a controversy to court.
It goes back to the question of controversy between what? Is there an actual controversy between subjects?
Yeah, or the subject and the state.
Yes. So if there's a controversy between the subject and the state, or between two persons who are subjects of the state. So it could be against one person against a corporation, or it could be a person against his employer. So you will see that those are instances of actual controversies. So it could be about employment law, or you feel like there's a violation of your intellectual property. So therefore, you file an action against a person who you felt plagiarized your book. In that case, that involves a matter. Now, if the task, however, is concerning intellectual property, for example, involves the power of determining who is possibly, violating the rules on intellectual property, in that case, there is no matter because there is no actual controversy involved. So what I have done, too much information was pointed out. What I have done was to provide examples of what matter is for the purpose of you having a more concrete idea of what matter means. Still confused?
Sorry, Manjo, I'm still really confused as well, and I actually thought I'd got a reasonable grasp on the assignment after I'd done it. So in the legal memorandum,
Yes.
The tribunal is going to look at the facts.
Yes.
And they're looking at the facts in relation to a specific individual.
Okay, go on.
Because they've been accused of something.
Go on.
So does that make that a matter?
No, that's not a matter.
Can you please explain why? I'm sorry, I'm really not getting it, and I don't think it's just me either.
Yeah, that's not a matter because there is no controversy between subjects.
Is there not a controversy between the individual and the state to make it a matter?
There is no controversy either between the individual and the state. Remember, it is the tribunal or the agency trying to determine, I can't remember the facts now. It is the tribunal. What was in the facts there? What exactly happened there? The power to investigate, was it?
Yeah, it was, does the tribunal have the power to investigate was one of the legal issues. Another one was, does the tribunal have the power to make a decision? I think perhaps what I and other people may be getting confused with is for the tribunal to look at a case, they will be looking at an individual who has been accused of committing an act of terrorism or been involved in homegrown terrorism.
Yes.
But if the tribunal is looking at an individual and looking at a person,
yes,
are they not looking at a matter because the state has an issue with their conduct?
No, the question is there a controversy? When the agency seeks to investigate whether or not a crime might have been committed, which might be terrorism, where is the controversy there?
The terrorism against the state.
But they're still trying to investigate that. Where's the controversy?
They're investigating the controversy in the first instance, the same as if you went to court in a tort action as well. You don't initially know that there's been a controversy. You're doing the investigations to start off with, and you're collecting your evidence, and you're trying to put your point across. So maybe I'm misunderstanding, but to my mind, I'm confused between the two as how there's an actual difference.
Okay, the word controversy is synonymous with the word dispute. So when you're still investigating somebody, obviously there is no dispute, right? You're still trying to determine whether or not, when you, for example, let's put it this way. We try to enter into, there are two persons who have entered into a contract, and somehow along the way, they're not too sure what the terms of the contract might be. And because they're not too sure what the terms of the contract might be, they feel it might be a good idea to just bring this to the court so that the court can determine if I do this specific act, I might be in breach of the contract. So in that case, the question I have is, would there be a controversy in that instance?
I understand that as a controversy, yes. Yes.
Huh? Where is the controversy? I don't get it.
They have a dispute between the two parties. Maybe I'm on my own here. I'm wasting everybody's time. I don't know. I'm sorry.
Where's the dispute? Where is the dispute? I don't get it. So we have a contract, the two of us, okay? And because we're not too sure what the term of the contract is, we would like, we'd like to bring it to the court so the court can inform us that if one of us were to do this specific act, then we would have committed a breach of the contract. So let's assume that if you make a breach of the contract, you have to pay $1 million. So to be safe, you want to bring it to the court so that the court can determine, if you were to do this specific act, am I in breach of the contract? Okay? My question is there a controversy or a dispute?
I'm thinking maybe Martin may be able to put it in my words.
Think about it.
Really good in the chat box.
Think about it. Was there a dispute or a controversy?
Are you saying that dispute and controversy are two different things?
No, they're exactly the same. That's what I said. They're synonymous.
Well, I'm sorry, Manjo. So, okay. So yes, I do think there is a dispute.
Where's the dispute there? I mean,
why are they going to court if there's no dispute?
No. That's exactly the point. If they were to bring it to the court will strike it down because it does not involve an actual controversy. That's the whole point. There is no matter. There is no actual controversy until such time commits a breach of the contract. Then you have a controversy.
Okay, I'm with you now. Okay, I'm with that. So for the tribunal, who is looking at a potential homegrown terrorist,
yes.
Why is that person there in the first place to be looked at and to be investigated?
Where's the dispute there? Where's the controversy?
Okay, Manjo, to put this, I'm just as confused, so I don't think you're wasting anyone's time, Catherine. Somebody just said in the chat box about a cop. What did they say? Hang on. I think it was Martin. The controversy arises when the cop or whoever it is has a valid opinion that you've committed a crime.
Okay.
So my opinion here, right, is the police officer who investigates a crime isn't deciding that you're guilty. They're deciding that there's enough evidence to send you to court.
That's right.
Right? In the matter that was before us in the legal memorandum, the minister was making a decision that you were guilty, i.e. you were involved in homegrown terrorism. Not that there was enough evidence to send you to court, but that you were involved in homegrown terrorism. So why doesn't the minister just define someone as being a murderer, and then if you're not happy, you can go to court? Why do we go to court for all these other things if the minister can just decide that you meet the criteria, so you tick the box and move on?
Okay. The point before the minister actually takes an action of arresting you, we will have to agree there is yet no dispute. Would that be correct?
Sorry, say that again.
So at the point, for example, in that situation where the minister hasn't taken any action yet, there is no dispute.
Where he's investigating you, or he's decided that you are a terrorist?
Okay, what was exactly the facts there? Can somebody write the facts for me so we can just focus on the facts?
I think the minister was to decide that someone was a terrorist was proposal 1, and then other things happened in the other proposals from there on.
Hold on. I'm just going to grab that one there. Hold on.
I think the one that I'm thinking of was number 2, where the minister could decide that you're in, or could, the minister could basically say that you're a terrorist and revoke your.
What I'm going to do is just to grab that, just to be sure, because we're not in a hurry anyway. Hold on, I'm just trying to look for the assessment now. Okay, not this one. Hold on. if I think I found it. Okay, so I found it. Hold on. Okay. Okay, that's the proposal 2. Okay. Would that be correct?
Yeah, proposal 2. The minister declares someone to be involved, so to be a terrorist, and revokes their citizenship. Why can't the minister just declare someone to be a murderer and put them in jail? What's the difference?
Andrew, the difference would be that it's a difference between the police saying, we think this person committed murder. There's actions that happen after that. So the difference between the example of the minister saying, you know, this person is involved in homegrown terrorism is essentially the same as police saying, we think this person is involved in murder. Things have to happen after that for the matter to happen. But what the minister is doing isn't a controversy. Correct me if I'm wrong.
No.
I guess I'm still not getting that, because the minister is still deciding that they are a terrorist and declaring that.
Okay. I think we're probably missing a step here. Now, at the time that the minister makes a declaration that a person is involved in homegrown terrorism and revoke his Australian citizenship, okay, that specific power, there is no controversy yet. The moment the minister actually exercises that power, that's when there is a controversy. And in that case, it can actually go to the court. Are you getting confused? So when in this case, the Minister of Immigration, for example, decides to declare an individual as being involved in homegrown terrorism and revoke his Australian citizenship, if he possesses dual citizenship, there is no controversy yet when he makes that decision. You know, the power to do that, there is no controversy.
Hey, Manuel, can I ask a question, please?
Go ahead. Yes.
So when we're answering these questions,
Yes.
obviously we don't know at what point the potential controversy is at. So we don't know if he has made that decision, and therefore there is the controversy. So when we're answering, do we say if the decision has been made, then there is a controversy because there has been an exercise of the power? Or do we say this legislation has just been passed?
That's
the legislation itself is fine because there's no actual controversy yet.
No,
so you'd have to wait for it to be. No,
that's not really the point. We're looking at the existence of the power. Just look at that power alone. When a tribunal decides to do something to you without you appearing before the tribunal with another person, for example, meaning it's on its own initiative, making a declaration or even revoking something from you. At the time he was doing this, there was no controversy. There was no dispute from the viewpoint of law. I'm having difficulty looking at
So Manjo, you're basically saying that there is no controversy and no dispute because a formal decision hasn't been made until the tribunal says that the citizenship will be revoked. At that point, then it becomes a controversy because a decision has been made.
Yes, that's only when there is a matter that can go to the court. So we're talking of the power to do that, to declare an individual as being involved in terrorism, or to revoke the citizenship, that power, we're looking at a power. There is no controversy or dispute. Okay? Now, when the minister then exercises that power and actually takes away the citizenship of a person, that person can then go to the court because now there is an actual controversy against the state. That's when Section 75 of the Constitution comes in.
So what you're saying, Manjo, is the minister can make any decision he likes about positive law.
Yes.
It's when he acts on it. That's when it becomes a controversy that a person can take it to court.
Yes.
Okay, thanks.
Was that clear enough? That's only then will there be a controversy.
The light went on.
Now, so the same thing with the police. The power of the police, for example, to say, I'm talking at the federal level. We're not talking at the states, remember? Because there is no separation of powers in the states. The AFP conducted an investigation and made the decision that you're probably committing a crime. It has that power. And it has the power, therefore, to arrest you. It has the power as well to even detain you for a certain period of time. It has the power to go into your house. Okay, so assuming those powers existed, was there a matter? That power alone, okay, we're just talking about the power to do these things. Does it involve a matter? No. Now, when they do something and arrest you, then you have a controversy. So, if, for example, a law was passed which said that the minister of the, the minister of immigration has the power to cause to determine which are, legitimate targets of an aircraft bombardment by the Australian Air Force. Okay, I mean, obviously, imagine that power. If they in fact bombard somebody or an area, that will cause untold hardship, or even it will cause the deaths of people. That power alone, wouldn't you agree? Now, that power itself does not involve a controversy, but when it is exercised, then that's when you have a controversy, and then you have a matter. Okay, so give an example. If a rap singer makes a record saying that he likes to take illegal drugs, is he guilty of taking illegal drugs? Okay, let's assume that there is a law which grants a government, a member of the executive government, the power. I'm not using the word guilty because the court has been very clear in the case of Chu Keng Lim that the power of making a declaration of guilt or not is only given to the courts. So that should just be emphasized. But if it was a question of making a declaration that somebody is taking drugs, and if the federal executive officer is then given the power to go to the house of that person to seize the drugs and even arrest him. So remember, there was a decision made whether or not, one, the person is probably taking drugs, and two, it has the power to enter the person's home to seize the drugs and even arrest the person. That power alone does not involve a controversy. Now, once it is then actually exercised, if the power is then exercised, so the police then, goes into the house of a person to seize paraphernalia or arrest a person, then there is a controversy, which then falls to the courts to adjudicate. Now, why is an ex parte injunction judicial? I'm not sure if that would be the way. It's not necessarily judicial in the sense that an ex parte injunction can actually also be issued by administrative tribunals. it can enjoin, for example, a government agency not to do this. That's right. Don't get confused about the formal aspects of the actual court processes. Okay, we're just looking at this point of what a matter is, and the crucial point really there to determine is there an actual controversy? So was that clear enough? Okay, so we could move on. Okay, hold on. So separate court process, which most people, oh. Okay, so you've got it. You've got it. Okay, okay. Thanks you, Brad. Thank you, Brad. So was that clear enough? We could move on. Okay, good. So I think it was necessary for us to have concrete examples instead of thinking of it in the abstract. Is the exam going to be this hard? I don't really even think it's a difficult exam. The legal memorandum to me was not that difficult. Confusing? Not really. I just felt it was actually easy. Yeah. I don't really think it's hard.
Yeah, Manjo, it's Amanda here. Can you hear me?
I could, Amanda.
You're the lecturer. I don't really think it's fair to say I think that the assessment, the memorandum was easy. Obviously, there are lots of us who are struggling. And for you to sit there and say it was easy, I've got to say personally, that really makes me feel so dumb because I am struggling and, you know, that really is really bad.
Yeah, I take that back. Okay, sorry. I take that back. I mean, you were asking me how difficult it would be. It could have been more difficult. I understand, you know, so I don't ask me whether or not it's difficult or easy because as I said, you know, it's quite relative. So I understand why, you know, it can be quite confusing for some. I understand that. And I'm not making any judgment. So I take away my earlier comment that the exam was easy. Okay?
Oh, yeah, that is something. I don't know whether you do realise that a lot of us are first year as well. So thank you for everyone who's putting those comments in. I'm first year and there's a few of us that are a little bit, that are struggling with it.
Yeah, yeah. Yeah, actually, administrative law is easier. Constitutional law is difficult because you're dealing with so many concepts all at the same time. Really, constitutional law is a difficult subject, in a sense. Yeah.
Yeah, Manjo, and I think they've changed it from a second year subject to a first year subject.
Yeah.
And I think maybe that a recommendation needs to go back, that needs to be reconsidered. Because as you say, it's pretty full on. And I'm a second year student at the end of my second year, and I didn't find it easy at all. So I can understand how Amanda would be feeling as a first year student. It would be pretty full on, I think.
Yeah.
I don't understand why they decided to change it.
Yeah, I can't remember the reason why this was changed because this used to be a year 2 subject. Actually, admin law is a lot simpler than constitutional law. Constitutional law is just so complicated because you're looking at the struggle between the federation of the state. Then you have a struggle about, you know, the different different branches of government. And I think there was even somebody who sent me an email who wanted to ask, how do you distinguish between quasi-legislative powers versus quasi-judicial powers? I'll try to raise that up with the others, but I think you've grasped it now, the notion of matter. So, you know, you have an edge going to the final written online assessment. Now, as I said, secondly, the topic on constitutional rights and freedoms will also be one of the subjects to be covered in the final written online assessment. So if we understand this more or less comprehensively, then again, moving, towards the exam, the final written assessment, you have an advantage as well. But constitutional law really is full on. Very full on. It's a very complicated subject. It probably takes you two or three readings of the textbook before you actually get it. Honestly, it will require you at least 2 or 3 readings of the textbook before you fully get it. That's just it's such a complicated subject. Okay, so having said that, it can indeed be difficult.
I feel like we should have all had this discussion about 6 weeks ago, though. I'm upset that I didn't bring this up earlier, but
something about matter or what?
No, the whole idea of how tough this is for first years. If it's tough for some second years, it certainly is for first years. And I really do think you've got to look at moving it, but regardless, that doesn't help us first years now.
Yeah, I think the reason is, when you talk about, for example, the notion of separation of powers, it's just too abstract. What exactly does it mean? Judicial power, what exactly does it mean? So, yeah, I'm going to raise it with the Law Discipline Committee when we have our meeting and see if it's possible to move it to a year 2 subject again. I'm gonna raise it with them. But really, it's a full-on subject, extremely difficult, really. I imagine. I mean, I could understand why. Now, how that assists? It will assist you because at least we're going back into those more difficult core topics. Yes. Who wanted to say something?
Sorry, Manjo, it's me again, Catherine.
Go ahead.
I just wanted to say that I've just listened to what Amanda said. I think she thinks she's gone off topic, but no, she hasn't. I think it's a really good point. I was qualified in the UK and I've got over 10 years experience. I've not done constitutional law. I've not done this before. I'm now currently just going into year 3 subjects and I found this extremely difficult, really, really difficult to grasp. And the memorandum took me hours, weeks, days, whatever to complete. And I think putting it towards the back end of the second year or even the third year is a really good thing to do. The introduction to law did cover the basics. That covered the basics of the separation of powers. It covered the basics of the jurisdiction of the federal courts, the state courts. Yeah. Enough perhaps to get you through the second year subjects as well without going into the in-depth, perhaps, way of writing as well as the actual subject.
Yeah.
That is in constitutional law now.
I'm going to raise those points with the Law Discipline Committee. I can't remember the reason why they decided to move it to change it to become a year 1 subject. I can't really remember what the reasons were.
Yeah, Manjo, I think that had to do with the change in crim law from advanced crim law being a second term first year subject, and now it's an elective, whereas it was a core subject. So constitutional law was taken down to first year to replace advanced criminal law.
Probably. You could be right about that. You're right. I think that may have been the reason. But I'm going to...
Sorry.
Josh, was that you?
There's also a number of electives that I couldn't choose because I did constitutional law in my second year and I want to get it done in 3 years because some electives are only offered every 2 years in certain terms. And so doing it in your first year offers a lot more flexibility where it comes to course choices, because constitutional law is a prerequisite for just about half of the courses, if not more.
Oh, is that right?
That I looked at. Yeah, from what I looked at, I had to cross off a lot of subjects. And I think I just want to balance out what everything has been said and offer something else that I personally think that if I did constitutional law in the first year, I would have been better off. I wish I could have done it in first year. Just because a subject is difficult doesn't mean you shouldn't be able to tackle it or shouldn't want to. I like to throw myself in the deep end sometimes, so maybe that's just me, but I think it is beneficial to do difficult subjects that are foundational to the rest of your legal understanding of some complicated areas of law. just like last year, I struggled in some areas of contract law and tort law or statutory interpretation. I know a number of people that failed that course, but that doesn't mean that it shouldn't be in the first year just because it's something that you might fail. So I personally don't think it's an issue just because people are having difficulty, because now obviously people are more enlightened and they've added it to their learning. So I don't get intimidated by it if it's really, really scary, because this isn't an easy subject to study. So don't expect it to be.
Yeah, let's put it this way. Most of you are going to pass this course. Most of you. I think majority will pass. 90% will pass. I think it's only about 10% who will likely fail. Hopefully less. So it means that if you pass this course, moving forward, it means, pat yourself on the back for having succeeded in completing the course. Okay, so again, I don't want to go to that issue about easy or not, because again, it's relative, but I don't think more than 10% will fail. I'm a reasonable marker. As I said, even though there was only one person who got proposal 2 right, a lot of people, I think about 11% of the cohort, got a raw score of 90 or over. Somebody had 97. I think 4 had 96. So at the end of the day, it's not so much having the correct conclusion, but I'm looking at the reasoning and the analysis that goes with it. Yeah. Okay, so let's move on. We'll go to constitutional rights and freedoms this time. As I said, I don't mind going beyond 8 o'clock. Now, for those of you who have got to go, I encourage you to really listen to the recording. In fact, let me just say this before we leave the topic about the assessment. I was quite I'm not going to say I was quite disappointed, because again, it might offend people, but I was just surprised why there were quite a number of students who were unable to actually properly identify legal issues 1, 2, and 3, because we cover that in the tutorials. Those were covered in the tutorials. And so therefore, the inability to identify the issue correctly really was surprising to me, because we went through that in the tutorials. In the special tutorial on the legal memorandum assessment, I covered those. And remember, being able to identify the issue is crucial, because it's like, if you don't know what the problem is, what kind of solution are you able to offer? In other words, if you don't know what the legal issue is, you may end up discussing things, but they're going to be irrelevant most likely, or you're trying to provide an answer to a problem that is not even a problem in the first place. So I came across a lot of students who just started rattling off and, dissecting something without even identifying what the issue is. Because in saying this is the issue, it signals to you that this is what I'm about to do. I'm going to tackle this problem. But if you just start discussing something, it's like, okay, where is this headed? And chances are, because you don't have a road, if you don't know what the problem is, chances are you're going to go off tangent. You're going everywhere because you don't have a roadmap. You don't know where you're headed. The issue provides the roadmap, the clear direction where you're headed, because you're meant to resolve that issue. And if you misidentify the issue and you look at that, you're going to get it wrong. Okay? So that's crucial. Begin by identifying what the legal issue is, or what the legal issues are. So moving on, we'll go to moving on. Let's go to the discussion questions. Now, can I get a volunteer to read the discussion question for us?
Yeah, I can do that, Manjo.
Patrick? Is that Patrick?
Yes.
Fantastic. Thank you, Patrick. Go on.
Can you just bring up the screen because I can't see the question? Sorry.
Oh, you can see the screen?
I can see you, but no question.
What? Oh, hold on. What does it mean? There is no question?
Oh, yeah, I can't see the question.
Oh, hold on. Ah, I get it. Yeah.
It's Maggie. I've got it.
Hold on, wait. Something's wrong with my Zoom. Hold on. I think I need to share screen. Yeah, I think that was a problem. Sorry, my mistake.
It's all right.
Okay, go. There, thank you. Sorry, my mistake.
Commonwealth Parliament.
Hold on. Sorry. There. Okay.
The Commonwealth Parliament passed the Border Protection Security Act 2013, making it an offence for an Australian citizen to engage in terrorism as defined by the Act, abroad or in Australia. The Act also penalises acts of terrorism even if done prior to the coming into effect of the Border Protection Security Act. Alan Lambert, an Australian citizen, was charged under the Act for engaging in terrorism with Jamal Islam, a named terrorist organisation, in Syria in 2010. Lambert seeks to challenge the law on the ground that he cannot be held criminally liable for an act that occurred outside Australia. He also challenges the law as an ex post facto law that punishes acts that were legal at the time they were done. Advise Lambert on whether his legal challenge is likely to prosper.
Okay, just quickly. Okay, the question is, because it's almost 8, would you rather that I give you the answer or we go through an actual process where you contribute something? How would you like us to deal with this? Okay, so Melissa says give the answer. Are we happy for me to just go straight giving the answer for now? Then I'll, okay, good. Okay, good. Okay. Are you going to give example answers to the final discussion questions? Let me think about that, because by giving examples, I might be giving away the questions themselves. Okay, good. Okay, so let's just focus. And as I said, I'm having difficulty trying to, answer the discussion question and looking at the chat box. So I'm just going to focus for now on the answer. Now, advise Lambert on whether or not his legal challenge is likely to prosper. I would advise Lambert that his legal challenge is unlikely to prosper. And the reason is that, in the first place, it is within the power of the Commonwealth Parliament to legislate in relation to external affairs under the Constitution. And it is recognized that when the Commonwealth Parliament legislates in relation to external affairs, it actually has the power to legislate in relation to acts that occur outside the borders of Australia. In this particular case, this refers to an act that occurred outside of Australia, therefore within the external affairs power of the Commonwealth Parliament, or in particular its geographic power. It is within the power of the Commonwealth Parliament, therefore, to legislate on the subject. And this was the ruling of the High Court in the case of Polikovic versus Commonwealth. Now, there is a second challenge that Lambert is raising, and that is he's alleging that it is an ex post facto law in the sense that it punishes acts that were legal at the time that they were done. It is true that in many jurisdictions, such as the United States and the Philippines, for example, there is a clear constitutional prohibition against ex post facto legislation. In these jurisdictions, so it's based on the Constitution, in these jurisdictions, it is assumed that a law that penalizes acts that at the time they were committed were legal is offensive to the notions of the rules of law. However, in Australia, although there is a written constitution, there is no written Bill of Rights. So in other words, there is no expressly provided set of rights and freedoms that are meant to be respected by the state in relation to its citizens. Because there is no written Bill of Rights. Instead, what we have would either be would mostly be implicit constitutional recognized rights and freedoms, as well as some of the express rights, which, for example, would be the right to trade and commerce across the states, or the right against the imposition of religion on anyone. So those are just some of the express rights. The others are implicit. So going back to the notion of an ex post facto law, because there is no constitutional, there is no Bill of Rights, we cannot use the legal principles that are observed in the United States or in other jurisdictions. And therefore, at the time when the colonies of Australia banded together to form the Commonwealth, they were actually aware of the existence of the United States Constitution, that it had a Bill of Rights, and yet the fact that they decided not to adopt a Bill of Rights indicates that they were not prepared to entrench in the Constitution certain fundamental rights and freedoms of the citizens. So therefore, in terms of applying the principles on what are constitutionally protected rights and freedoms, we cannot go to the jurisdictions of the United States. Now, in the absence of an ex post facto constitutionally protected right, it is therefore within the power of the Commonwealth Parliament to make a law that is actually ex post facto, because it is, for as long as it falls within one of its heads of power. In this case, it is the external affairs power. And the High Court in Polukovic also ruled that the fact that an ex post facto law may appear to be harsh and cruel, mainly because it does not give sufficient notice of a person that he can potentially be committing a crime, because at the time he committed it, it was legal. That is no ground for the judiciary to intervene, because that is a political question. Clear? So I was actually having an extended answer because I just wanted to provide the context. Clear? So we can move on. Now let's move on to the next question. Hold on. Okay. Patrick, again?
Yes. The Commonwealth Parliament passed the Anti-Corruption Act 2013 that penalised acts of corruption by Australians, including paying bribes to win a government or commercial contract. Jeff Bloggs, a well-known Australian based in Adelaide, was charged under the statute for bribing a government official in China to win a lucrative commercial contract in China. Bloggs seeks to challenge the law on the ground that he cannot be held criminally liable for an act that occurred outside of Australia. Advise Bloggs on whether his legal challenge is likely to prosper.
I would advise Bloggs against challenging the law, because his legal challenge is likely to fail. Again, the Commonwealth Parliament, hold on. There are two aspects, there are two heads of power on which the Commonwealth Parliament can pass, actually three heads of power on which the Commonwealth Parliament can legislate in relation, can pass the law concerning can pass the Anti-Corruption Act 2013. One is the external affairs power. Two would be in relation to the trade and commerce. And the third one would be trading or financial corporations. So there are three heads of power under which the Commonwealth Parliament can legislate. Now, the question about the legal question, whether or not it is legally permissible for the Commonwealth Parliament to determine as a criminal offense an act that was committed outside of its borders, which typically, under the notions of international law, seems to go against the idea of territoriality of a state. In other words, a state typically has jurisdiction only within its borders. The High Court has ruled that, in the case of Polukovic again versus the Commonwealth, that for as long as it falls within one of the heads of powers of the Commonwealth Parliament, it is permitted to legislate in relation to acts outside of Australian territory. So that's an easy answer there. Anti-bribery convention, possibly, if there is such a convention, even assuming that there is no convention, and this is a crucial point, even assuming that there is no convention to which Australia is a party, because remember, if we talk about the external affairs power, there is that notion of the treaty power. Okay, now assuming that the treaty power cannot be used because there is a convention, but Australia is not a signatory, would that mean that the Australian Commonwealth Parliament will be unable to pass legislation concerning the subject which was covered by a convention of which Australia is not a party? Did you get that question? I just saw something there. Okay, I just saw a chat somewhere, and I was gonna respond to it. So typically under the treaty power, for as long as remember, the power to enter into treaties belongs to the executive. The rule is, for as long as the executive enters into a treaty, it is then within the power of the Commonwealth Parliament to pass a law in order for that treaty to become part of Australian law. Because under the incorporation approach in Australia, a treaty does not become part of Australian law unless and until it is adopted or incorporated in a domestic law of Australia. So even if the Prime Minister or the Foreign Minister or any member of the executive department enters into a treaty or a convention or a multilateral agreement, that does not become part of the law of Australia until it is adopted or incorporated in a law by the Australian Commonwealth Parliament. So therefore, now remember the crucial point there is that if there is no limit to what the Australian executive can enter into as far as the treaty is concerned. So the Australian executive can enter into a treaty concerning education, concerning the environment, which are subjects which belong to the states. But the moment that the executive therefore enters into these treaties on subjects that do not belong to the states, the Commonwealth Parliament now has the power, using its external affairs power, to legislate on those same subjects. Clear enough? Now, the point I was making was that what if there is no treaty? Meaning there is a convention or there is a multilateral treaty, but Australia is not a signatory to the treaty, meaning the executive has not signed that multilateral treaty. Would it mean that the Commonwealth Parliament cannot legislate on a subject that is part of the treaty, assuming that the subject is not one of those fields on which the Commonwealth Parliament can legislate on under Section 51? The answer is it depends. If the subject of the treaty or the subject of the multilateral instrument or treaty of which Australia is not a signatory happens to be one of international concern, then it is permissible under the Tasmanian Dams case. It is permissible for the Australian Commonwealth Parliament to legislate on that subject under its external affairs power, even in the absence of a treaty having been entered into by the Australian executive. Clear enough? Moving on. Okay, question 51.
Just a question, Manjo. What case did you say that was?
The Tasmanian Dams case. I think it's Minister.
Oh, yeah.
Yeah.
Yes, I know.
Yeah.
Yeah, thanks.
Patrick?
Yeah. Under the Intimacy Private Protection Act 2009, it is a crime for a person in Queensland to photograph, or record or distribute, disseminate or publish a photo, image, recording or video of a sexually intimate act without the consent of the parties to the sexually intimate act. Mike Withers, a Queensland resident, was charged under the Intimacy Protection Act Queensland for distributing an email of a video of Shirley Reynolds, a member of the Queensland State Legislature, engaging in an extramarital sexual act with a football player. Withers argues in his defence that his dissemination of the sexual video is constitutionally protected as part of his right to free speech and political communication. Advise Withers on whether defence is likely to prosper.
I would advise Withers that he has a valid defence, because although the Australian Constitution does not provide an express right to freedom of speech and political communication, the High Court in the case of Australian Television Corporation ruled that the right to free speech and political communication is one of the fundamental freedoms that are implicitly recognized under the Constitution as a crucial feature of a society that is free and democratic. The fact that the sexual video related to an extramarital affair between a person and a member of the Queensland State Legislature therefore puts that video into the realm of legitimate public domain, of which the electorate and the rest of society have a right and an interest or a concern as to the activities of the members of the parliament. And for that reason, because the subject or the content of the video involves a duly elected government official, the dissemination of that video, therefore, would be covered by the right to free speech and political communication. Reserve right to knowledge. Yeah, that's part of the. That's exactly the whole point of freedom of speech and political communication, because the public has a right to know what's going on. Because if the public does not have the right to know what's going on, then it's difficult to control excesses and abuses by the government. So it is assumed that it is a fundamental feature of every democratic society that there should be freedom of speech and political communication. In the private life of politicians, let's just say that it's difficult to say that it's really more of a private life. It's difficult to argue that. Let's just say that public figures or elected officials do not have the same rights to privacy as private citizens. The fact that a person is an elected government official means that his life is now open to public scrutiny, whereas a private individual may be able to assert a right to privacy. It's difficult to argue that in the case of duly elected officials, because their behavior and their actions and their decisions are always open to public scrutiny as part of public accountability. What if there was Australian Television Corporation, the case there? It's what if it was stolen? Again, my focus in this question is that argument about the free speech and political communication. Okay, we're just saying that even in the absence, therefore, of an express recognition in the Constitution of the right to free speech and political communication, because that is an express provision in most written constitutions of other jurisdictions, the High Court has ruled that there is an implicit recognition of such a right, okay, as a fundamental feature of any democratic society. Okay, so we'll go to the last point. Question 52. No. Wait. I'm missing something here. Wait. Oh, there. Good. This is an interesting question. Okay. How many are still there? Because this is one topic which really I want us to think about. Sorry, I disappeared. Where are we? How many are still here? 23. Good enough. Okay, Patrick, do you mind reading it, please? Hold on. No. Not that one. There, go.
Yep, right. Acting on the basis of evidence gathered from a surveillance, the police arrested and detained Nick Frostman under the Border Protection Security Act, an act passed to combat domestic and overseas terrorism. After the police refused to release Frostman after his 12th day of continuing detention, Frostman seeks to challenge the legality of the act in his detention. Advise Frostman on whether his legal challenge is likely to prosper.
Okay, stop for a moment. Okay, I'm not answering that question yet. I'd like to ask a question concerning matter. Okay, I'm not yet answering the question. I'm just going to go back to the issue of matter. If the Border Protection Security Act gave the police the power to arrest and detain any person who has violated the Border Protection Security Act, does that constitute the exercise of judicial power? If the law gave them the power to arrest and to detain a person for violating the Border Protection Security Act, the question is, does that power constitute the exercise of judicial power? No. The answer is no. There is no controversy. It's not a matter yet. Good. So at least most of you are getting it. Now, the moment the police, come in and arrest and detain a person, let's assume that there is a tribunal. Okay, let's assume that there is, under that same law, a non-Chapter 3 court was created. And it provides that the Security Protection Tribunal has the power to examine actions of the police in relation to arrests and detention. Let me repeat the question. Under that same law, it provides that a Border Protection Tribunal is created, and it is not a Chapter 3 court. That tribunal has the power to review decisions made by the police concerning the arrest or detention of a person. Would that be in breach of the Boilermakers Doctrine? Would that be an invalid legislation or not? So the question is, would that legislation be valid if it granted that power to review the decisions of the police concerning arrests and detention? And it is not a Chapter 3 court. The question is, would that law be valid or not? Can I just see some answers here? Wait. How come some are still saying not valid? It is valid. At the point that the police arrested the person, there was already a controversy, right? When the police arrested a person, there is a controversy between the state, between the citizen and the state, or the police who arrested me. That involves, there is an actual controversy, it involves a matter. So therefore, a tribunal, which is not a Chapter 3 court, cannot exercise that power because it involves a judicial power. No. Arrested means charged. I'm not sure if it even matters. I mean, okay, I don't want to use the word matter. I don't think it's even relevant. The fact that the police arrest somebody, already arrested a person, and detained that person, therefore it constituted the deprivation of his rights and his freedoms. There is a dispute now concerning the legality of what the police did, because there is an act of an arrest. There is therefore a controversy. And because there is a controversy, it involves a matter which exclusively belongs to the courts under the Boilermakers case. So therefore, for that power to be reposed in an administrative tribunal or a non-Chapter 3 court would violate the Constitution following the Boilermakers case. Is the act of reviewing it the power to review? It is, yes. The power to review an actual controversy belongs to the judiciary or to the Chapter 3 courts. Now, no, hold on. We're not yet going back to that advice, okay? I was just giving a backgrounder on matter. Okay, Maggie? I'm not going, as I said earlier, I was not answering yet that question. Okay, I was just going back to the issue of matter to find out if, most of us are beginning to really grasp what matter means. So if it's a matter, it has to go to a Chapter 3 court. Okay, when I say matter, remember, we're talking of the federal level. Okay, we're talking of, the Boilermakers case refers only to federal issues. It doesn't involve the states. Because as I said, as far as the states are concerned, there is no separation of powers. Okay, so going back to that question, an act passed to combat, after the police refused, hold on. Frostman seeks to challenge the legality of the act and his detention. Advise Frostman on whether his legal challenge is likely to fail. Okay, before I answer that, can I just get people to say whether or not his legal challenge is likely to prosper or not? from Michelle. I don't know anymore. To prosper. Okay. Remember, challenge the legality of the law. That's a question. Legality of the act. So the question is, will it prosper or not? The answer is no. The answer is no. I would advise Frostman that his legal challenge, his challenge to question the legality or constitutionality of the act, is unlikely to prosper. The reasoning for this is that the Commonwealth Parliament has the power to legislate in relation to the defense of the Commonwealth and the defense of the states. The Border Protection Security Act falls within that head of power. Its purpose being obviously to combat domestic and overseas terrorism. That specific legislation can also be based on the external affairs power of the Commonwealth because it relates to overseas terrorism. The High Court has ruled in the case of Puljukovic versus the Commonwealth that the moment there is a grant of power to the Commonwealth, daughter making so much noise, that the moment that the Commonwealth Parliament has a head of power on which its ability to legislate is given, then that head of that power is deemed to be as ample and plenary as the courts will permit. Now, so are we clear? So what I pointed out there, number one, was that it is within the head of power, and two, if it is within the head of the power of the Commonwealth Parliament, the High Court has recognized in Puljukovic versus the Commonwealth that that power, therefore, is plenary, meaning plenary. It's complete. It's almost total. It's complete and ample. Okay? Clear so far? Now, let me change the facts a bit. What if that specific law provides that it is possible for the police to detain a person for a period of 180 days? I'm changing the facts for now for 180 days. So the law provides that the police can detain a person for a period of 180 days, even in the absence of a judicial warrant. Wait, I already answered the facts earlier. The answer is I would advise Frostman that his legal challenge is likely to fail. And I cited two reasons for that. The first reason is it is within the head of power of the Commonwealth Parliament to legislate, both under the defense power and the external affairs power, because it does refer to overseas terrorism. And as I said, the High Court in Puljukovic versus the Court of Appeals stated that for as long as the Commonwealth Parliament is able to legislate on a subject, then that grant of power is deemed to be plenary and ample. So they can make, if it is within the head of power to legislate, it is not for the courts to restrain the Commonwealth Parliament from the exercise of that power, even if it's deemed to be cruel and harsh. No, wait. We're not talking of detention with a fair trial. We're just answering at this time, remember, we're just answering at this time the specific facts. Okay? So did you get my answer? Now, I'm going to change the facts this time. Okay? I'm changing the facts this time. The law provides that the police can indefinitely detain any person in Australia for a period of 180 days, even in the absence of a judicial warrant. So this time, instead of 12 days, it's now, the validity of the law, which enables the police to detain for a period of 180 days. What do you think is the answer? Would the law be valid or not? Can I just get some answers here? Invalid. So what does yes mean again? Is that valid or not? Can I just say valid or invalid? Don't say yes or no. It confuses me. Can you just say yes? Is it valid or not? Is the law valid or invalid? Okay, good. So there's a lot of debate going on. There's a lot of disagreement. The answer is, I would advise Frostman that if the law provides that the police can detain a person for a period of 180 days, and for that reason, he has actually been detained, let's say, for a period of 5 months, I would advise him that his legal challenge is likely to prosper. The High Court has ruled that it is a common law recognized right in a society governed by the ideals of democracy that they have the right against arbitrary detention, and that the imposition of a punishment such as imprisonment is reserved solely to the courts. In this case, the imprisonment of Frostman for a period of 5 months would constitute punishment without adjudication by the courts of his guilt. And that is offensive to the notions of freedom within a society. And so therefore it will offend the Constitution, because the High Court has ruled that I'm trying to remember now the case. In the case of Chu Keng Lim versus the Minister of Immigration for Ethnic Affairs, that there is a constitutionally protected right against arbitrary detention. So are we clear? So it depends, therefore, on the periods. Are we clear? So if it's just 12 days, in that case, it is not as a punishment. It was more, the High Court has recognized in Chu Keng Lim versus Minister for Immigration and Ethnic Affairs that it is not a punishment for there to be a preventive detention. This is in the form of a preventive detention for the purpose of combating domestic violence. But if it's now for a period of 5 months or even 4 months, it becomes a punishment. And that becomes a punishment without adjudication of guilt by the courts. Only courts can adjudicate guilt. That is recognized. So the High Court has ruled in Chu Keng Lim, only courts can do that. Clear so far? I don't really know the answer about preventive for 2 months. It's for the courts. I'm just saying that's why I was making a difference between 12 months and 6 months. They're extreme. Now, if you're saying 30 days, I don't really know. I mean, I'm not part of the court, but I would think that 30 days would be allowable by the courts. They probably think that that's fine. 2 months, I don't really know. At what point is there a controversy? At the point that he has been arrested, at the point that he has been detained, there is a controversy. But it's reasonable depending on circumstances. Well, what do you mean by that, Catherine?
Sorry, so did the court consider what's reasonable depending on the circumstances of the offence or the implications if they let somebody...
Yeah, concerning reasonableness, we're talking here of the length of the detention without judicial warrant, remember? So,
yeah, so does that look at the crime and what they think is reasonable to actually detaining somebody?
Yeah, I mean, there is no case law on this in Australia, but I'm saying we can clearly see the distinction between detention without judicial warrant for 2 days or 12 days versus detention without a judicial warrant for a period of six months. We can see the difference. So it's likely for a court to say that it is reasonable for a person to be detained for a period of 12 days or even 30 days. I would argue it would be reasonable. Now, I'm going to change the facts again. Does question 52 have a judicial warrant? No, as I said, there is no judicial warrant. That's the point. That's why he's complaining. There is no judicial warrant. The police were just given the power to detain him for an indefinite period of as much as 6 months. Oh, wait. You didn't see that in the facts because I said earlier we were changing the facts. I'm using a different set of facts for us to probe this topic in greater detail. Okay. Now, can I move on? I'm just going to change the facts again. Are you happy? I mean, I could leave it like this, or do you want me to change the facts again? Yeah. The length of time changed the nature of the validity of the law. It became invalid when it allowed the police to indefinitely detain a person. Okay. Well, what does again mean, Maggie? You want me to go back to the answer? To the second fact, to the new facts? Or I can continue to change the facts. Okay, let's change the facts a bit more. Okay, so let's clear. Under the new facts I gave, the second scenario about the 180 days, I said that was invalid. Okay, Now, there is a law which was passed by the Commonwealth Parliament which says that if there is a suspicion of somebody having acquired Ebola after traveling abroad, that person can be quarantined in a public hospital for a period of indefinite period of 180 days or even more. Will that be valid? 180 days. In the first instance, in the second scenario I gave earlier, remember I said it was invalid. Okay? So now it's again 180 days. Quarantine. It means you're under detention. Is that valid or not? The answer is it would be valid. The High Court recognized, again in the same case of Chukeng Lim, that that does not constitute a punishment. That is for the purpose of the public community. In other words, the High Court has recognized that there are instances when an indefinite detention can be done validly in the absence of a judicial warrant. An example would be quarantine. Okay? In fact, in the United States, during World War II, what do you call that? The American government interdicted, incarcerated actually all Japanese nationals during World War II for about 2 years. Question, valid or not? Let's just say, there's a war going on. Somehow, there was a World War III, and it was mainly because, there are many terrorists that ended up being in Australia. And because of that, the question is, would it be permissible to indefinitely detain these Australian, I'm talking of Australian terrorists, for an indefinite time of as much as, no, not citizens. The context was Japan. So in the United States, the U.S. Supreme Court ruled that it was constitutional for the United States government to interdict and detain all Japanese nationals. In fact, some of them were American citizens, even in the absence of judicial warrant for as much as 2 years during World War II. Defense of power. That was in the context of a defense power. Now, I'm going to change the facts again. Okay? I'm going to change the facts again. Now, this specific law, the Border Protection Security Act 2010 said that I'll just change the facts a bit. How about this case of the boat refugees, okay, from India, from Syria, from Iran, whatever? If you notice, what the Australian government has done is to put them in an island, the Manus Island or whatever. Okay, and their freedoms have been denied, correct? And some of them have been there, have languished in an island for 3 years, 4 years even. Okay, so we see the facts. There is a law, assuming there is a Commonwealth Parliament law that authorizes the treatment of those boat refugees for an indefinite period of time. And so therefore, in that case, one of the boat refugees who has been in that detention facility for 2 years has complained to the High Court of that his indefinite detention violates his right against arbitrary detention without judicial warrant. Remember, he has been detained for a period of 2 years. Okay? Question. Would that law, which authorizes the executive to detain an alien for a period of 4 years, would that be valid or not? Can you just answer whether it's valid or not? Valid or not? Imagine 3 years, indefinite, and that obviously constitutes detention and a deprivation of rights and freedoms. Yes, the answer would be that the law would be valid under the aliens' power of the Australian Commonwealth Parliament. The case was Al-Khatib. That's right. Who said that? So in the Al-Khatib case, the High Court has ruled that the power of the executive and the power of the Commonwealth Parliament to legislate in relation to indefinite detention of aliens is valid and constitutional for the purpose of border protection. So there's a distinction, therefore, between the powers of the Commonwealth Parliament to legislate in relation to its citizens and in relation to non-citizens or aliens. There is a distinction. Okay? Good. So was that clear? Was that clear? Questions? I think we've covered it enough. Oh, wait, did I have a bonus question? Hold on. Oh, okay, I've got a bonus question. Do you want to go on? It's 8:30. I'm happy to go on. No. Yes, to some? Okay. So, Patrick, did you say no? Patrick, before you go, can I just ask you to read this question?
Yeah. The Commonwealth Parliament passed the Terrorism Prevention Act that provides that the Australian citizens or persons in Australia who contribute funds to the terrorist organisation ISIS are by such actions adjudged guilty of continuing terrorism and shall be imprisoned for a period of 5 years. Australian Freddie Kruger was arrested upon his return from Syria for violating the Terrorism Prevention Act. Freddie Kruger wishes to challenge the validity of the Act. Advise him on whether he has valid grounds for legal challenge.
Okay, so those who need to go can go. Thanks for joining us. Thanks for joining us. For the others who wish to stay, we could stay on. Now, before I answer that question, can I just get people to state the answers in the chat box? Is that act valid or not? Okay, the answer is the act would be invalid. This is an example of a bill of attainder. Again, which in the case of Fardon and in the case of Cable versus Director of Public Prosecutions, the High Court ruled that the specific identification of a person or a set of persons as having committed a crime and who are then adjudged guilty and subject to punishment without judicial intervention would offend. The constitutionally implied rights against arbitrary detention and arrest. Because in this case, it's called a bill of attainder because it is the Commonwealth Parliament which is making the determination of what constitutes guilt. And the High Court has ruled that the power to determine guilt of a person belongs solely and exclusively to the courts. Okay, so we're good. Yeah, we're good. Okay, so I guess that's it for tonight. We're gonna have the revision on Monday of next week, and as I said, this will be part of the assessment, the one on constitutional rights and freedoms. I'm more than sure you should be able to do quite well. And I thank you for your patience and for joining again, tonight's tutorial. Thank you, everyone, and I'll see you on Monday. Bye.